Good morning, it's Alex Woods here, posting on the sunny 7th of September 2014. I'm picking up what I discussed last month, which was the issue of compound interest payouts in payment protection insurance claims, where a refund has already been made by the banks, often at least a year, if not more, after that money's been paid out to the consumer. That's hence the title of the posting today, which is significant because it reflects a legal, or rather addresses a legal principle that's well established in English law, which is that of res judicata, also merger. If you're a geeky lawyer, it's related, and this is simply a rule or a law which is prescribed in common law that says to the world, if you're bringing a claim, you've got to be careful if the facts underlying that claim have already been adjudicated and a finding has been made on those same facts in a previous claim, or not necessarily previously in court, but in a previous adjudication process or assessment. And obviously in the case of financial concerning claims, that might be relevant if you've already had an assessment by the Financial Ombudsman Service or by a bank's complaints procedures. So that's the issue I'm going to major on today. It is the umbrella theme is, of course, compound interest claims in case of payment protection insurance redress relating to the time lost value of money. The fact that in wholesale, I mean, I don't think I've come across a payment protection insurance redress complaint that's paid out anything other than simple 8% on top of compensation for the PPI premiums themselves. So, and watch this space, because I've got a number of cases going to the courts at the moment that are addressing this very issue. So that's by way of preamble. I'm going to touch on three key areas that naturally fall under that main heading of two bites of the cherry, and then I'm going to go on to talk about some recent, sea change, or if you like, a change in the direction in which the wind is blowing in favour of consumers. And I'll touch on publication by the FCA as well as some recent case law, and a juicy little anecdote I've got from a consumer body and a very active and energetic individual member of a consumer body who's emailed me yesterday, and then I'll conclude and wrap up in terms of looking forward to the next steps and the next postings and results in these cases that I'm running, which are turning out to be something of precedent type cases. I got an advice from senior counsel yesterday at a top barristers' chambers in the Inns of Court across there over the river yesterday, and I perused it, and one of the things that he said is he's been through the whole gamut, the whole realm of judgments, case laws, cases, and he's concluded that this really is rather a new area of law. So, right, well, I think the first thing to say is that on the whole, banks have not required consumers to complete forms in full and final settlement of their PPI claims. Okay, so res judicata means two bites of the cherry, and where a person has agreed that the payout is in full and final settlement, and that's exactly why those words exist. Where a PPI redress payout does not include a requirement that the consumer fill in a slip and sign that it's in full and final settlement, then it's quite possible, in fact more than possible, quite likely that they will be able to reopen the issue in court. Of course, I'm talking about the courts here, but I believe that in respect of this issue of compound versus simple 8% interest, the courts are the appropriate tribunal for resolving the question. I don't feel, I've been in discussions and negotiations with the Financial Ombudsman Service and the Financial Conduct Authority over the past 6 months on this issue, and they haven't really given me a strong signal of the sort that I can take to the banks who are refusing to engage with this issue. And in a way, I think probably, in fairness to them, they will be quite interested in the outcome of these precedent cases, because the approach to interest to compensate someone for the time lost use of money that you've been deprived of 5 or 10 or 15 years ago, that you could then have used, that would have generated you more than simple 8% on top of that sum. I think that the Financial Ombudsman Service and the Financial Conduct Authority will be interested to see the outcome of what the courts decide on this issue, because they primarily follow the courts on this particular issue. We're not talking about assessment of the liability of a mis-selling complaint. We're talking about once it's been assessed and the bank has been found to have missold the product, then the issue falls to be quantified. The claim falls to be assessed, and the appropriate calculation of redress then needs to be done. This is something that is invariably done by the banks without a huge amount of involvement from the Financial Ombudsman Service or the FCA, and I think that's why it's kind of a rather hot topic. So that's the principal thing to say. If consumers are watching this video, you can bring a claim unless you have been required to fill in a full and final settlement form. Some banks did make that requirement. I think HSBC almost certainly did. There are 1 or 2 other banks who did, but the bigger players in the Lloyds, for example, didn't. So you may well be able to bring a claim if your offer didn't require you to accept in full and final settlement. Now, that being said, as is so often the case, and this is something I try and drum home to clients when they contact me, there's no general law. Every claim is fact specific, and therefore I'll just give you a couple of examples of where that principle may vary, that general point of principle may vary. Now, here's one interesting principle, and I'm relating it to a case that I'm running at the moment. It's where the bank has inserted into the offer letter a single sentence amongst all the other sentences that says this offer is in full and final settlement of your claim. Now, that on the face of it looks like arguably an end of the matter. However, unlike, for example, HSBC PPI claims, they haven't required the consumer to complete a slip and actually sign for full and final settlement. And if you start to drill into the individual facts of this case, the consumer has accepted this offer. Well, actually, they haven't really accepted this offer. They have been sent a cheque after a prescribed period of time has passed for the PPI refund, which is included for this simple 8%. So, that's the first thing to say. The other thing about this case is that the consumer was in very severe financial difficulties at the time. The bank took the unilateral decision, as perhaps it's entitled to take, because the consumer was in debt to the bank who had missold the PPI. The bank took the unilateral, i.e. made its own mind up without consulting anybody else, to set the PPI refund, the lion's share of the PPI refund, against existing debt that the consumer had, to set it off. Also, as I say, the consumer was labouring under heavy debts. In fact, the loan that the PPI refund was set off against had been taken out by the consumer in order to consolidate debts, including credit card debts. Moreover, this issue of interest, of time lost, use of money, is quite kind of technical. It's a techie point. Now, the letters tell the consumer, and this letter did, that the FOS guidelines had been followed. The principles of the FCA and the FOS, the complaints Bible that the banks have to follow and comply with, their interpretation of it was in accordance with the guidance. Now, it's not, in my view. I think if they'd applied the guidance, my reading of the guidance, you may say, but I think it's pretty clear. If they'd applied the guidance, and indeed I've had my views corroborated by an outreach officer at the FOS and a chap who's in charge of these issues at the Financial Conduct Authority. So I say that they have failed to interpret the guidance because they haven't looked at the individual circumstances of this consumer. They've been in a hurry to pay out a PPI refund, and they've told the consumer that simple 8% is standard. In other words, they haven't really, and don't forget there's an inequality of power here between the bank and a consumer who's in severe financial difficulties. This consumer severe financial difficulties, that the consumer has probably has little choice but to accept what is in print, the authority of a major bank telling the consumer that simple 8% is what you're going to get. So really there's simply no opportunity for the consumer to disagree with the bank's approach to the time loss use of money on top of redress paid in the PPI complaint. Now, here is a letter in a interest rate swap case. I'm not going to tell you which bank it is. I don't want to alienate banks unnecessarily, and indeed I think some of the things that they say about claims management companies and being the bonnet they have about CMCs is often justified. Anyway, in this letter, which is an offer letter in an interest rate swap case, interest rate swaps are like to businesses what PPI is like to consumers. Is an easy guide to understanding what an interest rate swap is. They are quite complex financial instruments that were flogged, I don't think that's too strong a word, to businesses, unsophisticated businesses, before and during the recession, and they have been, the banks have accepted that they've been missold in vast quantities, and so there's a similar process that has followed the PPI scandal, a similar scandal in respect of interest rate swaps. Now, in the case of interest rate swap payouts, which chronologically have followed the system that's been set up as post the system set up to deal with the PPI scandal, in these cases, on this page, on the second page, the bank in its offer letter has a section on consequential loss and invites the consumer to, if they don't agree with the approach of the bank towards consequential losses at 8% simple interest, then they can make specific reference to their individual circumstances, submitting a specific claim for consequential loss in respect of identifiable costs incurred or interest rate not earned as a result of the missale of the interest rate swap. Now, in other words, and the section begins, this redress offer includes interest at a rate of 8% per year, simple. So, in other words, the banks are doing in interest rate swaps what I believe they should have done in the case of payment protection insurance refunds. But no, they haven't. They've hidden the issue. I'm not saying it's malicious or deliberate, but it's rather kind of convenient because it would be rather expensive to deal with this in 2008 when the scandal first broke. They've and perhaps the FCA and the FOS have taken their eyes slightly off the ball. They've hidden this issue from the consumer. Now, that is an example of an individual case where I believe in the round the lender shouldn't be allowed, in fact, even though they've got final settlement in the offer letter, shouldn't be allowed to get away with raising res judicata, 2 bites of the cherry, as a way of kicking the claimant's claim into touch before you've even started legal proceedings, which is what they do. They'd apply to have the claim struck out for breaching the law on res judicata. So that's an example. Now, I've got an example that goes the other way. It's quite interesting. And this, again, is a recent case where we've settled. And we've settled without a win. We've settled, both sides have borne their own costs, and we have simply, because, as is often the case in litigation, things come out of the woodwork as you get close to trial. And in this case, things have come out of the woodwork from the client end, and that is the fact that the bank had actually virtually written off or charged off the loan on which the PPI had been missold years ago, so long ago in fact that basically the client has got a free bunch of money that they wouldn't have otherwise have been entitled to. And the bank has decided to charge it off, or it's a technical word, write it off. We're not sure whether it's been sold or not, but anyway, the consumer's not having to pay any repayments on that loan. So, it wouldn't be equitable, I think, in that case, for a consumer to bring a compound interest case for loss of the use of the money, which could have been used to reduce higher borrowing costs, such as credit card debts that the consumer had at the time that they were paying out, that they were paying monthly repayments for their PPI loan, fixed term single premium PPI loan. Now that's a case where there wasn't full and final settlement written into the letter, so the consumer wasn't prevented from bringing their claim in the courts. However, in the round, it simply wouldn't be interesting to a judge to agree to pay out extra money. This could have almost have doubled the claim, extra money for the loss of the time lost use of money for that consumer that they could have used to reduce their credit card debts in this case. The other thing to note about that case is that the instructions from the client weren't very clear, to be frank. It wasn't clear that the client would definitely have used that money to reduce their other borrowings. So this brings me on to an important issue, which I'll just come to shortly. But if the consumer wasn't actually, going to use that money to reduce their credit card debts, let's say they were going to use it to go on holiday, then again, it wouldn't be appropriate for a court to award compound interest on top, an additional refund of compound interest. So that brings me on to the issue of causation. And again, I'm just remember that generally my view is that these claims can be brought, but I'm giving you examples of considerations that you need to have before you ever think about bringing these types of claims. So the second consideration would be causation, and this is illustrated by the case that I've just referred to, where in fact when you look at the facts of the situation, the consumer wouldn't have used that money to reduce other borrowings anyway. It's not just a case of reducing other borrowings, they might have used that money to invest in a business or to save a business from going under. Again, that would be a very strong argument for a payout of something other than simple 8% interest, compound interest. Because the fact is, we live in a world where borrowing money on compound interest is commonplace. So that's another key consideration is causation. And to give you an example the other way, you may have someone who is deeply in debt, they're a credit card junkie, and they have been a claims management company, or because they're probably not able to get their head around it themselves, has helped them to deal with their debts, and a PPI complaint has been made to a bank. They may even be in insolvency or in an IVA, in debt management, and a claim has been made to the bank, and it's just clearly the case that simple 8% would not sufficiently compensate that consumer for the considerable debts, as well as the fact of an adverse credit rating, for example, which would make it very difficult for them to borrow at anything other than high compound rates in the future anyway, if the PPI contributed to that, for example. So you can see where in a situation of someone who's having severe debt difficulties, they would more probably than not have used that money that went to the bank to pay for the single premium PPI, the monthly payments for the PPI. They would probably have used that money to reduce other high compound interest indebtedness. So there you have, so the issue of causation is obviously a key consideration. Finally, I'll just quickly mention this. It's really a topic for a much longer video. But our experience of running this batch of what we're calling true loss claims, additional refund claims, compound interest claims, is you do come up with the unexpected, to be fair. So in one case we have come up against a limitations issue because the facts go back before 2005. We've come up against an issue relating to the fact that the PPI may well have been sold alongside a first charge mortgage. We've got an argument about whether it was or it wasn't, and that could compromise the claim somewhat. We've also got these issues that I've alluded to, where actually a consumer hasn't really suffered compound loss, and really they wouldn't stand up in court as a very good witness. In fact, you probably wouldn't want to get them anywhere near the courtroom doors. And another bum biter that we've stumbled across is where actually a consumer has completed a PPI questionnaire. Has signed a PPI questionnaire back in the day when they very first made the complaint, but they haven't really filled in the boxes, and the boxes have been ticked by a claims management company keen to bash off a claim in order to get their 25%, and so it's not the questionnaire is not a truthful account of the mis-selling in question. So you've got those issues. Don't forget, by way of conclusion to this section of the video, don't forget that in these true loss cases you are dealing primarily with something of an admission by the banks as to the mis-selling of the payment protection insurance in the first place. Now they're rather cheekily having basically agreed, for example, in some cases that the PPI was unsuitable for that client, and in respect of these cases they're now deciding to fight that and to say that even though they paid redress and even though they accepted the product was unsuitable, that wasn't an admission for purposes of legal proceedings, it was something else, which, I mean, is a bit rich, and it kind of makes you think the law's a bit of an ass if a bank can admit to something being missold and then they can find a way to navigate their way out of that problem, out of that particular plastic bag, because they've got clever enough lawyers and the law is complex. So although that's can be a problem in these cases too, on the whole that's just simply a question of it makes it a little bit more tricky for us to win the case. But I think that on the whole those offer or admission letters or goodwill gestures can be used, and this is, I have counsel's advice on this, can be used as evidence when it comes to convincing the judge that he should make a finding for the consumer in respect of liability, because this is another bum biter, if you like, that you may consideration you may have to deal with, is that the bank is making you rerun the arguments over liability all over again. So there it is. That's the general picture. I think consumers are entitled to bring these claims, and the law will allow them to bring these claims, but of course actually bringing them in practice is a whole other kettle of fish. However, I will say, on concluding in a more positive note, that the winds are blowing in favour of consumers in this area. there's a case called Plevin, which has been heard in the Supreme Court. It's the first time the Supreme Court has been asked to rule on the unfair relationships test, and which is a key bit of relatively new consumer legislation. And the judgment will be handed down in autumn, and it will be interesting to see whether it's a positive, consumer friendly or not. The vibe is, the feeling is that it will be a consumer friendly judgment. The other thing is the FCA have just produced a report, and in that report, and here I quote from a letter I wrote to an opponent. This report only came out last week. The FCA have produced a report in which, and I quote from their press release, in another positive move, banks, credit card providers and personal loan companies have agreed to reassess more than 2.5 million complaints from 2012 and 2013, which they may have either unfairly rejected or paid too little redress to. So it seems as if the FCA may be waking up to this problem of the fact that too little redress has been paid, and this relates not necessarily to compound interest but to credit card charges, where people's balances have gone over a limit and they've incurred different charges, but the banks haven't compensated the consumers for the fact that their overdraft limits or their credit limits have been exceeded in their PPI refunds. And this, what I'm talking about here, compound interest, is, falls into that same category. And the other final thing that I will mention, actually, well, two final things I'll mention. One is a bit of case law called London Scottish Finance, which is authority for the fact that compound interest is the unfair relationships test allows a judge to make an award of compound rather than simple 8% interest. And the final thing is, this is an email that I've got from a consumer champion. He does it for love, as far as I can tell. He helps people challenge the quantum of their claims in PPI redress cases, and he says, just a bit of an update if you're interested. A little group I've been working with managed to show the FCA that MBNA and probably others have been, in inverted commas, cooking the books with PPI redress calculations, and they agreed to investigate. The FCA have agreed to investigate this. The BBC's Mike Robinson reported on Lloyds and others using what he termed alternative redress to reduce claim payouts. Anyway, it's becoming clear, and I'm afraid to say the PPI scandal trundles on like some great big dirty black caravan, and I'm afraid these, with each year or with each month that passes, a stone is unturned and an ugly little creature crawls out from under that stone. And it seems that in the case, as far as this month's concerned, redress calculations and the fact that the banks haven't been paying out full and proper compensation in all cases, because we are talking about a significant minority of cases. Right, so I think I will conclude there, but I will simply conclude by saying that I'm posting monthly. I think weekly is a bit ambitious. I'm just too busy at the moment to post more regularly than each month. But next month I will give you an update which will include by that time I expect one of our cases at least to have had a ruling, a judgment handed down on this very issue of res judicata and bringing claims through the courts for additional compound interest, even though a consumer has accepted an original offer, sometimes often as long as 1 to 2 years previously. Okay, so watch this space. Goodbye for now.